However, we can acknowledge that there are also other people who come to play when we're trying to create our work that make a major contribution. When you're creating a film, you have actors, you have composers, you have screenwriters, you have producers who contribute to bringing that work to life from a concept or from a script. And these people are owed what you call neighbouring rights. The law in Section 20 of the Copyright and Neighbouring Rights Act defines neighbouring rights as rights attached to auxiliary roles played by performers, producers of sound, recordings, and audiovisual and broadcasting companies. So rights for performers, sound recording producers, audiovisual producers, and broadcasters usually are the people who fall under this category. And basically, this protects those who deliver our work. If I've created a song and somebody else performs it, their performance is protected, and they are able to also earn the rights that are attributed to them by bringing that work to life. These rights do not affect the original author's underlying copyrights. They simply run alongside them. So what are some key neighbouring rights that this entails? Is fixation. So the performer, for example, can control who records their live performance for the first time. If I go and perform a film or a play or a song, I can control if NBS can record it, if UBC can record it, and if anybody, for example, puts it up on YouTube without my authorization, then I can go and enforce my rights for the infringement of the work. Then there are also broadcasters who are owed neighbouring rights. They can authorize what live performances go on air. So if I have recorded a news, any information for the news and put it up, then I will have broadcasted it, and I will have I'll have the authority to allow any other broadcaster or radio station or TV station to continue airing it. If anybody does that without the authorization of the original broadcaster, then they've infringed on the copyright. But then, how long do these rights last? They don't last forever. So for literary and dramatic works, screenplays, scripts, audiovisual works that are produced, all of these are available to the owner for 50 years. After 50 years, the protection expires and the work enters what we call the public. The work is 50 years after the death of that creator. Then there are also what we call anonymous works, pseudonymous works, or even orphan works, which has recently been introduced into the law. These ones are typically 50 years from the time they've been discovered, 50 years from creation. However, if someone in the course of those 50 years comes and claims the work and they can prove that they're the owner, then we go back to the default, which is the death of 50 years after the death of that owner. But yeah, so those are the timelines. After that, all works go into the public domain and they are used freely.